So today we're going to be talking about the offer to purchase and contract, and this is a standard form here that we use in North Carolina. It's a 17-page form, and this is the contract that we would use when you are ready to submit an offer for a client for a home, the home of their dreams. So it is not an actual fully executed contract until all parties sign. So when we first submit this offer to the seller side, it's just an offer to purchase. Nothing is binding, nothing there's no responsibilities or anything that you have to adhere to until the seller side accepts the offer and they sign. That is when it will become an actual contract, and we are under fully executed contract. That's when all parties have signed. So just wanted to make that clear with you all to let you all know it is called an offer to purchase and contract, because it doesn't mean that just because we submit it, it's going to automatically be accepted. The sellers could go with another client, and therefore this is this addendum, this purchase, this offer to purchase is null and void. Again, it doesn't become an actual contract until all parties have signed. And this next section is just talking about this actual contract is between the sellers and the buyers for valuable consideration, receipt of a legal sufficiency of which are hereby acknowledged that the buyer's offers to purchase and sellers upon acceptance agrees to sell and convey the property on the terms and conditions of this offer to purchase and contract. So it's just stating again that these two parties are agreeing. The seller is agreeing to what the buyer is submitting in this contract. And this contract is between the seller and the buyer. The seller is coming first in this particular contract because the seller is the one that's selling something. So there wouldn't be a need for a buyer if there was nothing being sold. So this is why the seller is coming first in this particular contract. We want to know, as the buyer, is there will there be a manufactured home or will there not? Will it include a manufactured home or not? And will it include any of these other items as well? Any offsite and separate septic lots, boat slips, garages, etc. So what this is saying is that if it does, in this little note, if it does, we need to make sure that we identify it, the serial number, identification number, and the additional provisions, addendums, which we will attach to this particular offer. So we again just want to make sure that when we went and viewed that home and you've seen all these other things on the property, it could be a manufactured home, it could be a riding lawnmower, it could be a lot of different things. We cannot just assume that it comes with the property, that it's being conveyed with this actual sale. The sellers could take that with them when they move. So again, we just want to make sure, so we would check off yes it will or no it won't in this section, and if it does, we will add it to the additional provisions addendum and all the other necessary serial numbers, identifications, to make sure that you are receiving this once we close and those particular items are there. So let's move on down here to the street address. And that's pretty self-explanatory. We're going to be placing here the 123 Main Street. Let's just say that that's what this property address is. So this is right here in this little note. What it is saying is governmental authority over taxes, zoning, school districts, utilities, and mail delivery may differ from address shown. So this portion right here, this is what that's talking about. This legal description is going to differ from this 123 Main Street. We obtained this from the tax records, and if you're a realtor, you can also get this from the MLS. There's a tab called the Realist tab, and you can also get this information. But again, this information is going to differ from this one, but it's still the same. It's still coinciding. What is just a little bit more detailed, should I say. So it comes with, some of it has a plat references, which is a lot, a block, section, a subdivision. It's going to have the plat book and the pages of that as well. It'll have the PIN number and deed book and the pages as well on that. So we'll just fill in all of those slots, but again, it's going to differ from the way the street address looks, but it's still one and the same. So we just want to make sure that you are purchasing the correct property. So next up is the purchase price. So this is where we're going to put in here what we are offering, what we're wanting to purchase this home for. So whatever that amount is, that's what we're going to place here. This is a due diligence fee. We're going to place that amount here, and on the due diligence fee, this needs to be made payable directly to the sellers, and it needs to be, I need to collect those funds on the effective date. The effective date, again, is when all parties sign, when we're under executed contracts, and this is the payment methods that that they accept: the cash and official bank check, wire, etc. So it is important to know that once we are under fully executed contract, that fee made payable directly to the seller, and we're going to discuss that in page 2 a little bit more in detail. What is the due diligence fee? But I need to collect that pretty much at that time. Now, realistically, within 24 hours, I need to collect those funds. And then we have your earnest money deposit, the same thing. This is the method of payments, but this is due 5 days. But for convenience, I always let my clients know, when you go to the bank, just go ahead and get your due diligence fee and your earnest money deposit all at once. Deliver it to me. I will collect those fees all at once. So it'll be a little bit easier transition, instead of meeting with me one day and then 5 days later meeting with me again. We'll just collect it all at once, and then I'll get those over to the seller and get this over to the title company, the attorney, or escrow agent. That's who holds your earnest money. And again, we're going to talk about these two terms in a little bit more detail in page 2. But again, the due diligence fee is made payable to the seller, and the earnest money deposit is made payable to the attorneys, who's going to hold your earnest money in escrow until we complete this transaction. Now, again, just to let you know, any monies that you submit, even this additional earnest money, and I'll explain that a little bit too, you get credit for that at the end of the transaction. Once you complete this transaction, you will get credit for that. This is not something that the buyers just, there's money that they're throwing away. So please understand, as buyers, you do get credit for that. And the way that looks, real brief, is if your lender lets you know that you have to bring $5,000 to the table once you close. So when we go to settlement and you sign all of those documents at the end, you're needing to bring $5,000 to close, and that could be a combination of your down payment, closing costs, etc., etc. So what they'll do is give you a credit for these items that you have already paid when you place this, submitted this offer. So let's just say this is $3,000 with the combining these three items. You put $1,000 in due diligence fee, $1,000 down for your earnest money, and you came back and did another $1,000 for your additional earnest money. That's $3,000 altogether. They'll take that $3,000, give you credit for that, so that $3,000 is subtracted from that $5,000. So now you only have to bring $2,000 to closing. So it makes it a little bit more easier when you understand that, and you don't feel like you're just throwing money away. So I hope I was clear on that. And this additional earnest money, it is what it pretty much said. It's additional. Let's just say if you're military, and you don't have to be military, but you're getting paid every 2 weeks, you're going to put down your initial earnest money deposit on the 1st for $1,000, and then we're going to come back on the 15th and place another $1,000 by 5 p.m. on the 15th. So we're just stating that in this contract. This is a good faith estimate. This is a good faith deposit, letting the sellers know that you're really serious about purchasing this home, in addition to your due diligence fee as well. And it shows them that you do have some skin in the game as well. So that's it on the due diligence fee, earnest money deposit, and additional earnest money deposit. And again, this is the amount that you are going to, that you're saying, this is what I would like to purchase your home for. Then now they'll take a balance. The computer will automatically generate, or either the system that I use will generate the balance here. So what it is whatever you offer to purchase, it's going to subtract those monies and it's going to give you a balance. This balance is what you will be getting financed for, or if you are paying cash for this particular property, this is where that figure will go. And we are at the end of page 1, and so at the end of every page we are needing initials here from the buyers and the sellers. And what that is stating, the initials is saying that you understand everything that was said previously. So if you put your initials, sign your initials in this these boxes, just understand you're saying that you're fully aware of what has been stated here. And this next box here, let's get it highlighted. This is talking about the delivery of the due diligence. So it says, should buyer fail to deliver either the due diligence fee or any initial earnest money deposit by their due dates, or should any check or other funds made payable be dishonored for any reason by the institution upon which the payment is drawn, buyers shall have 1 banking day after written notice to deliver cash, official bank check, or whatever. So this is what this section here is talking about. It is talking about, okay, above when we talked about the due diligence fees, the earnest money deposit or additional earnest money deposit, if your bank dishonors that, they're giving you 1 banking day after written notice to deliver that to them to make good on what we have stated again in this contract. So it's important that we take care of those things expeditiously. We communicate very as much as we possibly can, and you as the buyer are communicating with your realtor to let them know, hey, I'm out of town right now, I'm out of the country, I just had orders, or whatever have you, because you have 1 banking day to get that right. Now, as long as we know what's going on, you're in transitioning a PCS, and it might take you a little bit longer to get it, a couple of days longer, more. We just need to know that so we can let them know. And whatever it is that we decide upon, this note is saying that if the parties agree that the buyer will pay any fee or deposit described above by electronic or wire transfer, the seller agrees to cooperate in effecting such transfer, including the establishment of the necessary account and providing any necessary information to the buyer. Provided, however, buyer shall be responsible for additional costs, if any, associated with this transfer, with such transfer. So again, what that is saying is, whatever we decide to do, if you are, want to do it expeditiously and you want to make a wire transfer, but there's additional fee, you can't make the sellers pay for that fee. So you need to pay for any additional fees that is going to be associated with it. So if it's $500 that you owe, whenever you do whatever transaction that you do, we need to make sure that the sellers is getting that complete $500, if that makes sense. So let's move right along here to this next section, which is the earnest money section in here. And this is stating that the initial earnest money deposit, the initial earnest money deposit, the additional earnest money deposit, and any other earnest monies paid or required to be paid in connection with this transaction collectively, the earnest money deposit shall be deposited promptly and held in escrow by escrow agent. The earnest money deposit will be credited to the buyer at closing or dispersed as required by the contract. And I had stated that in the first page. So any monies that you put in this deposit, in this transaction, you will get credited for that in the end. You're not just throwing money away. So we just want to make sure that you do understand that. And sometimes it works out that you get a credit back. So let's just say you were supposed to bring $2,000 to the table, and you have placed those $3,000 in deposits, the fee and the earnest money deposit and the additional. you will receive $1,000 back because you're gonna get credit for that $3,000. You only had to bring in two, so they will subtract the $3,000 from the $2,000, and that will leave you $1,000. So you will receive money back at closing. So hopefully you're understanding a little bit more, and if you're a realtor, you can explain this to your clients. If you're on our team here at Moving Virtual Assistants, I want you all to understand as well this contract, so that when we are facilitating transactions from contract to close, we are able to explain these contracts and what this means to our clients. So this is where this is what it's saying in this earnest money deposit section. So in this next section, this is where whatever the attorney's name is, that's where this is going to be. We're going to fill in that escrow agent, attorney, or title company. This is where their name will go. So in this next section, what this is talking about, if there's any dispute over the earnest money deposit, over the earnest money deposit held in escrow, a licensed real estate broker is required by state law, and the escrow agent, if not a broker, hereby agrees to retain the earnest money deposit in escrow agent's trust or escrow account until the escrow agent has obtained a written release from the parties consenting to its disposition, or until disbursement is ordered by a court or a competent jurisdiction. So what this is saying is that okay, in the contract, there is with the due diligence, that goes directly to the sellers. You never get that money back unless there's a breach of contract on the seller side. But with this earnest money, we have a period, and we're going to come and we're going to get ready to talk about that. But if there's a dispute here with this earnest money, we can't just go get the money back. All parties have to sign in this entire contract. And this is what this section is letting you know. If there's a dispute in this transaction of you receiving this money back, what we need to do is get an addendum that you will sign as the buyer, and the sellers will get the seller's agent will get the sellers to sign for release of this money. So once I get that addendum, then I can give it to submit that to the attorneys, and then and only then will they be able to release you your earnest money deposit, if that makes sense. We can't just go get it back because you want it back. I mean, if you terminated this contract, there's a necessary steps that we have to take. You have to get all sides to sign off on every addendum attached associated with this transaction. It's not a one-sided thing. So if one party doesn't sign, whatever that document is not binding. It will not stand up in court. So if there's any type of dispute on the earnest money, we need to get together as the buyer side and the seller side, get the necessary addendum together, all parties sign, and then we submit that to the escrow agent, and then your funds can be released. And this section right here is just letting you know that the parties agree that a real estate brokerage firm acting as an escrow agent may place the earnest money deposit in an interest-bearing trust account, and that any interest earned thereon shall be disbursed to the escrow agent monthly in consideration for the expenses incurred by maintaining such account and records associated therewith. So it's just letting you know that if the real estate firm is acting as the escrow agent, that monies are going to be in a interest-bearing account, letting you know that money, the earnest money that you're submitting, is going to generate any type of it'll generate and earn interest. So they're wanting you to know that money will earn interest, and they will submit that in consideration of any expenses incurred by maintaining such account. So this is what this section is. So we're getting down here to section G, which is the effective date. And what this is saying is that the effective date of this contract is when the last party signs. So once we, as the buyers, we submit the offer over to the sellers, the effective date is not when we send it over to them, because when you sign the documents, it will have a stamp date on there. It's not executed, and it's not effective until the other party signs. So sometimes we can submit an offer and we don't get an answer back within, it could be 24, 48 hours. So whenever that time is, that's when the effective date, that's when everything starts, when that effective date is, when the last party signs. So now we're here at the due diligence section. Now this is, let me highlight this part. This is the buyer's opportunity to investigate the property and the transaction contemplated by this contract, including but not necessarily limited to the matters described in paragraph 4 below, to decide whether buyer in buyer's sole discretion will proceed with or terminate this transaction. So this is the due diligence is the buyer's opportunity to do whatever inspections that they need to do on the property. It's a 2-week period that you have to decide, even if you still want to go through with this contract. Just understand that in this next section, the fee that you pay to do this, which is you're paying the buyers, you're paying the sellers to take their house off the market, so you can take your time in this 2 week to decide if you want to sell, if you want to purchase or not. If you do not, you can walk away with no explanations at all. You don't have to give an excuse or anything. You can walk away from the contract. However, just understand still, the due diligence fee, you don't receive that back. This is what you're paying them, to let them know that, hey, I'm paying you to take your house off the market. I'm paying you to get out of jail because I am signing this binding contract. So this is also, it's a get out of jail free card that I can walk away from this without being penalized. Basically, the only penalty that you're getting, which is really not a penalty, you're paying them to do so. So this is how crucial this section is. This due diligence, the due diligence fee is next. Everything is negotiable in real estate. So we come up with an amount that you feel comfortable with submitting. You don't have to submit anything at all. It's not mandatory, but however, it does strengthen your offer, especially when we are in a season where it's a seller's market and not only you want this property, but there's 10 other people that wants this property. A due diligence fee, it speaks and it talks to the seller. So it is something that is advisable to do, but we cannot make you do it, and it's not mandatory, and the amount is up to you and what you can afford, what you can comfortably afford to lose, if that makes sense to you. So I wouldn't offer anything that, if you're having any type of second thoughts in your mind, if you think that you may walk away from this deal, don't offer anything that you can't afford to lose. So this is what this section is stating about this fee and what it is. In the due diligence period, again, I think I touched on that. From the actual effective date is when your time clock starts, and it is 2 weeks from that effective date. So that's the period that you have to do your investigation, to do your inspections, and this to even mull it over and talk it over, chew it over with your family and friends on if you really want to purchase this home. If you purchase the home, if you choose to walk away from the home throughout that time, you don't lose nothing but your due diligence fee. However, if you walk away from it after, and let me digress, if you walk away during the due diligence period, you lose the due diligence fee. However, you can you'll get your earnest money back, and we talked about that earlier in this section about the earnest money. But just to add a little bit more to the earnest money, when we were talking about this negotiation of it, right here, this dispute area, this is what this means. So in the event that you walk away after this period, so let's just say this period here, this date is March 20th, and you want to terminate after March 20th, you will then risk losing your earnest money deposit, if that makes sense. I'll slow down again. If you terminate during this period, you are owed your earnest money. But if you terminate after the due diligence period, now there's a battle between us and the sellers. The sellers can say, sure, just go ahead because of whatever, the situation is. If it is a legitimate reasoning, sometimes the seller will say, hey, we'll allow you to get the earnest money back as well. However, they don't have to. Because if you, in this contract, it already is stating that if you terminate after the due diligence period is over, you are forfeiting your earnest money as well. So in that section above, as far as in the negotiation of it, again, remember I talked about that addendum that we would have to put together a termination with or without the earnest money. We would have to get all parties to agree. The sellers had a soft heart and they said it's okay, then you would need to sign. They would need to sign. We will get that over to the attorney's office and they will release you your earnest money. However, they didn't have a change of heart. We're 3.5 weeks into the contract. They have lost money by their house being off the market, and you, for whatever reason, it could be just because you changed your mind, you got cold feet, some negotiations didn't work out the way, or you did something and something happened and you didn't get the final pre-approval. They can say no. You will have to sign that addendum and they will have to sign that termination agreement as well. We would get it over to the attorneys. However, the attorneys would not release it to you. They would release it now to the seller. So this, it could get pretty sticky. That's why I always tell people, just make sure when we are signing this contract and you're seeing this home that you really love this home, because it can get sticky in the, in the middle and the end of it when it comes down to releasing these monies, these funds. So now we're almost at the bottom of page 2, or we are at the bottom of page 2. We have this one section here, which is the settlement section. In the settlement here in North Carolina, that's the time where you go to the attorneys at the end of this contract. It takes about 4 weeks to close here, give or take 4 to 6 weeks if something goes, wrong or if there's a delay. But usually we're closing in about 4 weeks here in North Carolina. That's when you go and sign all those documents. Take you about 30 to 45 minutes to sign, and understand that also the keys are not released at that particular time. So in North Carolina, we do not release the keys to you as the buyer until the deed is recorded. So once all this paperwork has been signed, the attorneys will take this to the courts, and the courts will let us know when they have recorded. It usually happens within the day. However, just being honest, just prepare yourself maybe that it won't, depending on their schedule and if they're backed up or whatever. So that's why I like to close anywhere Monday to Thursday, because even at the latest on Thursday, we will close that next day. So you should be able to receive your keys on Friday. I don't like to close on Fridays because there's a risk. Even if we close Friday mornings, for some reason, sometimes it happens and we don't close that day. You're frustrated as a client because I cannot release those keys to you, and you have kind of pretty much wasted the weekend, because usually people like to move on the weekend. So I won't be able to release those keys to you until Monday. So I just want to make that clear and hone in on this section here. Settlement is just when, and we call it closing as well, but it's actually not completed until the deed is recorded, and settlement is just when you are signing the documents, no keys are released. And then to just add to that, nothing happens until the deed is recorded. We don't get paid, the nothing gets funded, the lenders don't get paid, the attorneys don't get paid. Nothing happens until the deed is recorded, if that's any consolation. So again, at the end of the page, we are looking for signatures from the buyers and the sellers. Again, this is stating that you understand everything that has been said prior to these initials.